Hello and welcome back to The Lawyer You Know. Today we're going to be covering the Supreme Court nomination process, which has gotten a lot of news. So if you like content like this, make sure you subscribe to our channel and we'll give you more information that you can use every day about what's happening in the law. So today's topic about the nomination, we're going to cover three things basically. One, we're going to start with the law about a Supreme Court nominee and what the law and the Constitution has to say. Secondly, we'll go into the process of how a nominee becomes a nominee and how that nominee becomes confirmed and gets appointed to the Supreme Court. And the last phase we'll talk about is the specifics about what's going on right now with President Biden and how President Biden is selecting someone and what kind of person do we think President Biden is going to select and what kind of a reception that person is going to get in the United States Senate. So let's begin. First, where does this come from that the president nominates a Supreme Court justice? Well, in the Constitution, we have three branches of government. We have legislative, we have executive, and we have judicial. Obviously, the judicial branch includes the United States Supreme Court. The executive branch selects, being the president, selects a nominee, and then that selection goes to the legislative branch, which is the Senate. So all three branches are involved in the nomination of a Supreme Court justice. Article 2, Section 2 of the Constitution states that the president shall nominate and by and with the advice and consent of Senate shall appoint judges of the Supreme Court. That's all it says. So he nominates, he sends it to the Senate for what's called advice and consent, which means they have to consent to the appointment, and judges of the Supreme Court. Notice it doesn't say how many judges. We've talked about that in the past, whether it has to be 9 or can it be 13, and the numbers have changed over the years. But right now we have 9 Supreme Court justices. And when they go to the Senate and the Senate has to approve them, how does the Senate approve them? They do it and they can do it by their own rules. So they can pass whatever rule they want of how they proceed when they talk about this advice and consent of the Senate. So some general information first. The Supreme Court of the United States. Do you have to be a lawyer to be a Supreme Court justice? You heard me read what the Constitution says. Doesn't say anywhere in there you have to be a lawyer. And in fact, 2 justices of the Supreme Court in the past did not go to law schools or did not graduate from law schools. Some of them didn't even graduate from high school. In one case, he studied on his own and he passed a bar exam, so he became a lawyer and they appointed him. But he didn't even graduate from high school. So you don't have to be a lawyer. Another question is, what is a majority? Do they have to have a quorum in order to sit when they meet? Do all 9 justices have to be there? A quorum for the Supreme Court is 6 justices. So if 6 justices are present, then they can have a meeting and they can make decisions. But we also need to know in today's modern age, a justice doesn't have to be sitting in the courtroom. We recently had an oral argument where Justice Sotomayor actually sat in her chambers and watched it over a closed circuit video because she was worried about a COVID infection because she has diabetes and she's high risk. So she wasn't even in the room. They can also make a decision if they read the transcript of the hearing or listen to an audio of the hearing. Even though they weren't there, they can still vote on the decision of the Supreme Court. So they don't have to be present. So what else do we need to know? Well, how does the process work? Well, a president selects a nominee. And how do they select that nominee? They do it through a review process where they send out feelers to their friends, lawyers they know, judges, political individuals, people who contributed to their campaign. They all suggest people. When those people come in, those people are reviewed. White House counsel, which is the lawyer that's inside the White House, hired by the president and selected by the president, that office probably has the greatest influence on who they're going to select. So White House counsel goes through the nominees and with the president in discussions and maybe various other people, very important people to the president, people the president trusts, they narrow it down to a group. Right now, what we're hearing about in this group is they've narrowed it down to kind of 3. My guess is there may be more than 3. But 3 are the ones that we're reading about in the paper. So when they do that selection and they kind of narrow it down, then what they do is they get the FBI to do a background check. They want to make sure there's nothing in the past that is going to cause any kind of embarrassment or disqualify this individual. If you will remember with Justice Kavanaugh, when Justice Kavanaugh came before the Senate, all of a sudden there was a lady who accused him of inappropriate conduct. That never turned up in the background investigation done by the FBI. She came up on her own. But the FBI does try their best to go and talk to everybody. Friends of mine have been appointed to the judiciary, the federal judiciary. The FBI have come by my house or come by my office, interviewed me about that person. What do you know about the person? What do you know about their background? How are they socially? Do they drink too much? Ever known them to take drugs? Ever known them to do anything inappropriate or make inappropriate comments or racially motivated comments? Those are all questions the FBI asks when they do these interviews. And like I said, they go to everybody this person ever knew, ever had contact with, anybody they had a trial with. They interview all of them to find out this background. So you've got the FBI doing a thorough background check. This background check not only goes to the president, but it also will go to the Senate committee. They have the right to review the confidential material. So after the background check, after the president decides who the person is, the president will nominate someone. Normally, a hearing occurs roughly between 40 and 50 days after the nomination. That hearing will occur before the Senate. The president then sends the name to the Senate. The Senate does their own independent investigation. They will send their own investigators out in addition to the report they get from the FBI. Again, background check, anything embarrassing. If you're a judge and you're appointed, which has been the modern way now is to appoint federal judges or state court judges, they'll look at every decision you ever wrote in your life. The questionnaire can be as much as 100 pages from the Senate to the individuals that are coming before the Senate committee. If you've given a speech, they want to know about the speech. If the speech was videotaped, they want a copy of the videotape. If you ever wrote an article in any kind of a magazine or newspaper, they want a copy of every article you've ever written, every decision you've ever made, every court case you've ever participated in, every lawyer you ever tried a case against or who tried a case before you as a judge. All those names and all those people get looked at and reviewed. I've had one particular friend that was appointed to the federal bench call me because he remembered writing an article when I was president of the Florida Association of Criminal Defense Lawyers that went in our magazine. And he couldn't find the article. And he called me because the FBI wanted a copy of that article, which was one of many articles he's written. And we had to track that article down digitally somewhere and find it so that we could turn it over to the FBI so they could turn it over to the committee. That's how detailed the review is. Before they go before the Senate committee, the Senate Judiciary Committee, which, by the way, is the current committee assigned to all Supreme Court nominees. They all have to go before that committee. Didn't used to always be that way. Used to be you didn't have to go before a committee. For a while, they didn't even have a Senate Judiciary Committee for this review. But in the modern day, you do have to go before the committee. Also in the modern day, the nominee appears before the committee. The old days, nominees sometimes didn't even show up for the committee meetings. But today, they all show up. So before you show up for that questioning, which can last up to 4 or 5 days, the last couple have been 4 or 5 days at least, you go before what's called a murder board. This murder board is something that helps you prepare for that committee. It's called a murder board because it's designed to ask you the worst of the worst, the toughest of the toughest questions. They can pick out one line you wrote 30 years ago in a college thesis and ask you about that line, and you have to explain it, and you have to be ready to explain it. If you ever watched the Supreme Court hearings for Justice Barrett, the most recent appointee, the one thing that everybody was astounded about is she had this little piece of paper in front of her, not stacks of books like some nominees have to review the article. she had a total recall of almost everything she had ever done. And it was an amazing thing to see how her mind worked, and how just that little piece of paper for her to jot down a note once in a while was all she needed to recall everything she'd ever wrote or everything she'd ever said. And it was all brought up at that committee meeting. So these murder boards, Justice Roberts said that he did 10 of them for 3 hours apiece, 30 hours of facing questions to be prepared for what the Senate committee was going to ask. So after that happens, after the murder boards, the committee hearings are set. You go before the Senate committee. Another group that is very influential at the Senate committee is the American Bar Association. The American Bar Association reviews all Supreme Court candidates and gives a recommendation to the committee. Sometimes the ABA is considered biased. Some Republican presidents wouldn't share a lot of information with the ABA because they said they had a Democratic leaning. But the ABA still gives a recommendation, very qualified, qualified, or unqualified. They are normally, in probably 90% of the Senate hearings, the first witness to testify before the Senate. And they tell the Senate what the recommendation is, the chairman of the committee, appointed by the ABA, and they tell them why they made this recommendation about this candidate. The Senate committee comes in, they do their questioning, and things have changed over the years. For instance, in the Senate committees early on, it pretty much was if the person was just plainly qualified, they'd get the vote. For instance, you've got Sandra Day O'Connor, you got Anthony Scalia. And now Scalia was obviously very conservative. Everybody knew he was conservative. Stephen Breyer, the Supreme Court justice that's just retiring now, who's going to have his seat taken by somebody else that President Biden is going to appoint, he was very liberal. Everybody knew he was very liberal. However, Scalia in 1986, Breyer in 94 got unanimous approval. Republicans and Democrats, all of them, voted to approve them. And that kept on through almost unanimous all the way through until we get to the latest appointments, which is about 2009, things really changed. At that point, it was a total party line approval. Sotomayor and Kagan got strictly party line votes. 13-6 was the vote on both of them. And then when you get to Alito, Gorsuch, Kavanaugh, and Barrett, total party line opposition. They were approved, but only strictly total party line opposition. And then you go back to 87, which is when Justice Bork was nominated. When Justice Bork was nominated, he was the first one in modern times to be rejected by the Senate. He did not get approved. And it's called borking now. It's actually a nickname for it, by someone that just gets trashed in the committee, trashed on the Senate floor, and then doesn't get approved. There's also been individuals appointed or nominated that things look so bad for them in the Senate committee that the president has withdrawn their nomination and put somebody else in there because they knew this person was going to fail, and so they figured, why waste the time? Let's put in somebody else. And the other one besides Bork that did not come out favorably in modern times was Clarence Thomas. Clarence Thomas did not have a favorable or unfavorable vote because it was a tie, and he was sent to the Senate floor and approved, even though he was not approved out of the Senate committee. So that's the history now, and things have become far more contentious. So what's happening today? What are we looking at with this current appointment? Well, first, I told you that the Senate counsel is the White House counsel, very influential in selecting who's going to be picked. Currently, the White House Chief of Staff is Ron Klain, K-L-A-I-N. Why is he so important? Well, let's take a look at his history. He was counsel to the Senate Judiciary Committee. He used to be the lawyer for the committee that's now approving the Supreme Court justices. So he knows all about the confirmation process. He knows all the rules, everything that should be done. He also was the chief of staff for Vice President Biden. So he knows Biden very well. And remember, President Biden used to be the chairman of the Judiciary Committee in the Senate. So he was the one that used to approve Supreme Court nominees with the committee. So you've got a real history. You've got a lot of experience with Supreme Court nominees sitting in the White House now to pick the right one. So how has Biden done so far? What can we look at his history to see how his appointments have done from all his federal judicial appointments? Well, one thing he's done, 26% of all his federal judicial appointments have been black women, far and away more than any other president. Currently, 69% of his federal judicial appointments have been people of color. How does that compare with President Obama, who he was vice president for? President Obama's selections of people of color for judicial appointments was 40%, compared to Biden's 69%. So we know what Biden is trying to do. We know where his emphasis is. But is it right? And this is something I'm going to ask you, and really want to hear comments on this. Is it right to, when you're campaigning, to say, I'm going to select a black woman? Is it right to box yourself into that as part of a campaign promise before you're even president? So is that correct? Now, one other president has actually promised when they were running that they would appoint a woman. So using that as a campaign promise, when you make campaign promises, you do it for votes. I mean, we all know that. So is it right to use the Supreme Court as a vehicle for getting votes when you're running for president? Some people say yes, some people say no. Some people say yes because they take a look at the history. And they take a look at, for instance, there's been 115 Supreme Court justices in this country. 5 have been women, 2 have been African American. So why shouldn't a presidential nominee make it known to the people that are going to vote for him that he wants to appoint a black woman? Or is it correct to say that because black women are 6% of the population, that they deserve that percentage of Supreme Court justices? Considering what percentage white men are, is it right to say, should we have so many white men as Supreme Court justices? They argue it both ways. Is it right to say that you're going to not only have a litmus test of black woman, and is it right to say, well, let's criticize that litmus test because you should only look for the most qualified person? That should be your nominee. And when that most qualified person is appointed, people shouldn't say they were appointed because they were black or a woman. Or is it absolutely positively correct to say, I am sure that there are black women that are just as qualified and have the same ability to be a Supreme Court justice without ever looking at their race or their gender? It's a tough question. And there's a lot of arguments on both sides. I mean, let's face it, there's arguments on sides about Ivy League schools. You know, everybody on the Supreme Court went to Harvard or Yale except for Barrett, and she went to Notre Dame. So that only the last appointee on the Supreme Court did not go to Harvard or Yale. And the women that are being considered, those top 3, 2 of them went to Harvard or Yale. One of them, from South Carolina, actually went to the University of South Florida as an undergraduate. And she is up for consideration, and she went to, I believe it was South Carolina Law School. So she is nowhere near a Ivy League person. Do we have diversity if we do that? Do we have diversity if we only have people who think like Ivy League people on the Supreme Court? Do they know how the rest of us think? Do they know how people in South Florida think? So all of these criteria, all of these arguments about what the diversity should be, Those are all legitimate arguments. And again, we'd like to hear from you about what you think. So this wraps it up. I hope you have a better understanding now of how the process works. And, oh, one other thing, the Senate vote. When it goes out of committee, it goes to the Senate. Up until 2017, the Senate had to vote 60 votes because it was the filibuster-proof vote, and it was a supermajority. So 60 out of the 100 senators had to vote to confirm a presidential nominee for the Supreme Court. In 2017, that was changed to a majority. It's called the nuclear option. So now it only requires a majority vote to approve a Supreme Court justice. Thank you very much. Thanks for listening. Please subscribe if you enjoyed it.
Thanks for watching this episode of The Lawyer You Know. If you like this content, please share it with your friends. Make sure you subscribe to our page and like our videos. If you want some interaction, get in the comments and we'll be sure to get back to you. If you want to know any more information about our firm or this page, you can find out in the description or visit tragoslaw.com. We post multiple times throughout the week, so make sure you hit that bell so you can get the notification and not miss out on the next episode.